All right, we will now go to our discussion item, which is Section 0280, Commission on Judicial Performance, Issue 1, the State Audit. I forgot to ask for a public hearing. Good afternoon. Or it's actually morning still, but what have you, barely. Go ahead.
Thank you. I'm Judge Erica Yew. I'm from Santa Clara County. I've been on the CJP since December of 2010, and I'm a former chair. I served as chair for 2.5 years. Thank you for allowing us to be here.
Great.
Rick Simpson, Vice Chair of the Commission, retiree.
I'm Victoria Henley, Director and Chief Counsel for the Commission on Judicial Performance.
Okay. All right, so the item is before us because the Commission on Judicial Performance is obviously budgets under this subcommittee, and the adjustment budgetarily, the adjustment for the commission didn't really warrant hearing because it was just a baseline adjustment, though it is an adjustment of $70K. So in other words, it's an increase from last year's budget to this. If adopted, this year's budget would have an increase of $70,000 to the commission. But what we have before us is that the Legislative JLAC Committee had voted unanimously for a audit of the Commission on Judicial Performance, which is my understanding when I read the background that there had been no audit in the past. And subsequently, the Commission on Judicial Performance has petitioned the court as basically suing the state on with the premise that while there's various things in the legal document, the two primary purposes of the suit are asserting that the Commission on Judicial Performance, due to its constitutionally separate role from the legislature, would not be subject to such an audit. And thus, they're pursuing, or you are pursuing, a court action to prevent the audit. And I found it very interesting and would like to hear your explanation, because clearly the University of California has while the legislature approve its budget, it does also have a constitutionally separate role, and our powers, the legislature's powers, are limited in relationship to the university, and thus I'm sure limited in relationship to the judiciary. But it's not been either my understanding, my interpretation, or obviously the legislatures, that somehow that would also free any such entity from being able to be audited by the state auditor. So as we've seen recently, the University Office of the President, they probably wish that they had filed such a suit. But no, instead they were audited, and the audit results were not very favorable, and now they're, it's caused a lot of brouhaha. But they subjected themselves to the audit. They did not choose to go to court. So your explanation.
So thank you so much for allowing us to be here. We're very appreciative of the opportunity to talk to you. We wish we didn't have to file the lawsuit, actually, and we tried several times to talk to the auditor's attorney to have the audit start. In paragraph 16 of our lawsuit, we actually say we believe that we should be under your authority to audit us. And we have had, since September of 2016, materials pulled together to provide to the auditor. And we're concerned that that hasn't been communicated. Not only have we pulled together information to respond to the audit, we have actually created a matrix which correlates the specific requests with the material that we believe is responsive to the audit. We were not able to come to a resolution with the auditor's attorney on the issue that is primary concern to us of confidentiality. And so we felt between a rock and a hard place because we felt we could not release the confidentiality. We're not the holders of the confidentiality. We don't have any interest in, these cases personally, but we're really stuck. And we needed to have a court adjudication to help us. The reason why we're stuck is we have a constitutional mandate to maintain confidentiality, and that's also recapitulated in our rules. And I can tell you on a personal level, I've been in hearings where the complainant is someone, we know who the complainants are and the judges don't. And the United States Supreme Court recognized why that's so important, because when you're doing investigations of individuals with a lot of power who can abuse that power, you need to let those complainants be confidential to a certain point so that you will get those complaints and you can investigate misconduct. And this commission has done a great job of making sure that judges who shouldn't have that job are removed from office or are disciplined or receive some indication that what they're doing is not proper privately so they can readjust. But I've been in hearings where the judges said, well, I know my staff never complained about me because my staff loves me. And we know that it's staff who complained. And we know those staff still work there in that courthouse, sometimes still with the judge, because if a clerk doesn't have a judge, they don't have a place to put their purse, they don't have a place to have lunch. I mean, they're bereft of a lot of things. So we don't want to have to violate the confidentiality of those complainants when the Constitution and the Commission have promised them confidentiality. On the other hand, there are some really great judges who have made a mistake. And in deciding to accept the Commission's private discipline, they've taken that lesson and moved on. And I can tell you, judges have come before the Commission and are sometimes tearful because they feel that the Commission's discipline is such weight to them and it's an eye-opening thing for them. They learn a lot. We have promised them confidentiality, which they relied on when they accepted the Commission's discipline. We can't give up their confidentiality, so we're really stuck. And we wanted some type of adjudication to protect us.
So,
Madam
yes,
Chair?
Mr. Simpson.
Part of our fundamental concern about confidentiality is that while the government code does say that the auditor's staff stands in the shoes of our own staff with respect to access to and maintaining confidentiality, the government code also says that records collected by the auditor for purposes of their audits are public records and are subject to the PRA. That's a conflict that the auditor, neither the auditor nor the auditor's counsel has been able to resolve. So part of our fear is that if those confidential materials, as Judge Yew said, we have witnesses, we have complainants, we have judges who have received complaints that were baseless. If those pursuant to a public records request would become public, either there could be retaliation against witnesses or complainants, or judges who are running for re-election would have unfounded allegations available to, out in public. So we're kind of between a rock and a hard place. We think there's a conflict in the law, and so we've basically asked the court to help us understand what our responsibilities are.
And when
So-
so sorry.
Thank you. Certainly, the confidentiality issues are legitimate concern, but certainly there are many agencies within the state government that have, I'm not going to say perhaps equally important confidentiality issues, but do have records and other such things that under law must be kept confidential. And yet the auditor, they're seemingly, and again, I can't cite, seemingly the auditor's office has been able to figure out an accommodation to handle that. But what I find more interesting is that while the presentation so far is that the concern is primarily confidentiality, this petition to the court does not just say, give us a clarification on the confidentiality records. It has three. It seeks three, and the clear statement in the opening of what the purpose of this lawsuit is that to refrain from auditing as required by the separation of powers doctrine. And that is in two different portions of, you only have three reasons you are asking the court to intervene, and two of them are because you do not believe that the state auditor has the right to audit. So if it were solely and only that you were trying to get the relief from the court as to how do we resolve these confidentiality issues, I think it perhaps would have at least a different approach.
And I'm not sure.
Could you identify your?
Yeah, Victoria Henley.
Right.
And I'm not sure that the petition either was intended. We did state in, I believe it's paragraph 21, it is stated that the commission, believes that the auditor does have a right to conduct an audit and lists, fiscally, staffing, personnel, procedures, all of which we were fully prepared at the first day of the beginning of the audit and made all of that information available to the auditor. I think the issue on the separation of powers is limited, and we've just responded to pretty extensive discovery from the auditor as to what, and it's basically only as to 3 of the 19 audit categories and has to do with the commission's deliberative decision-making. And as compared to times when the auditor has looked at, for example, the state bar and said, well, the state bar was doing too many lenient dispositions, settlement dispositions, they based that on the fact that the Supreme Court had rejected various recommendations. In the audit request that we received, it said that the auditor wanted to sample a number of cases, and one of the categories, which is item 12, the only 3 that are contested on the separation of powers issues is 2, 5, and 12, because they all go to the commission's deliberative function. And rather than, for example, saying, well, let's look at the commission's reversal rate, which is, public and, fair game in terms of the constitutional framework for the review of commission decisions, which is done by the Supreme Court. Item 12 seeks to evaluate the outcome of a selection of cases and evaluate the discipline that was imposed, which does seem to go to the commission's core deliberative decision-making. But please be clear, and I'm happy to give you the responses to the interrogatories, because the commission made very clear in those, which apparently was not clear in the petition, that it's only with respect to the commission's deliberative decision-making in 3 of the 19 categories that the commission believes it intrudes upon a separation of powers.
Okay.
May I add?
Yes.
Thank you. And I'm so sorry for the cough. It's bad allergies. It's paragraph 16 that says we're definitely subject to the audit. And I think it was it was probably the fault of the lawyers and the judges on the commission, because I know as a judge, when we see these lawsuits, if people don't present, thank you so much. If people don't present all the arguments, then the bench will see that it's waived. And so on advice of our attorney and sort of wanting to just be careful and to not waive anything, the petition did include every argument. But really the primary concern for me, at least, and I know a lot of the members, all of us actually have unity on this, is the confidentiality. We really feel it's important to protect the witnesses, the complainants, and those judges.
Okay. I don't necessarily have an action on this item. I just felt that it was appropriate to have a discussion, because clearly, since we are making budgetary decisions, well, I guess one question might be what the cost so far of the legal effort.
And I believe we provided that information, and I think it's at about $68,000. I would also like to say that we offered to the auditor when the declaratory relief action was filed, and we had set up a meeting which was canceled, not at our request, and never rescheduled. We offered to do this as expediently, as efficiently, and to try to save costs for all of us. We had our lawyers, we instructed our lawyers to please come up with the easiest way to avoid factual disputes, avoid doing the discovery, which we've now spent a month doing, to try to do this in as straightforward and as easy and as economically as possible. The auditor was not responsive and basically told us to proceed however we saw fit, and they wouldn't agree, for example, to stipulate to a single judge, to stipulate as to how factual issues could be resolved without doing discovery. So unfortunately, this has been painfully expensive for us as well.
As because clearly you have costs beyond just the costs of the external legal counsel, but your own staff time. And so from a budgetary point of view, we can imagine if all the agencies within the state were to sue the auditor when the legislature asks for the auditor to do an audit, create a lot of havoc around our budgets. So I don't know if any of my colleagues want to make any comment? Senator Beall?
I'm on the Joint Legislative Audit Committee, so I have a, so what's the status of the audit right now in terms of timeline?
Nothing.
Well, they did not accept our offer, refused to go forward, even though we indicated as to all of the categories that are not disputed and particularly not involving confidential records, they declined to go forward with that. We still have the materials. We prepared the, groundwork for what they need to look at for all of that, and they have elected not to do that.
Okay, have you, when we approved this on the 10th of August last year, our committee approved it. And usually there's a request with a letter saying, here's what we want to audit. Did you respond to that and point out these problems at that time?
We only received the letter from JLAC. The request came in, as I believe, late for that committee, and so I think we received about 7 days. We were asked to come to the hearing. We had the chair, the committee meeting, and we were prepared to be there, and it was put on the consent agenda, and there was no discussion.
So you didn't say, hey, wait a minute, we want to talk about this?
And we did not get the auditor's report until the morning of that hearing.
Well,
I mean, we received the request, but we didn't get the auditor's, whatever you call the auditor's letter documenting what would be done.
well, usually there's a letter that somebody writes requesting an audit. Okay, there's a
Right.
letter from a legislative member. They submit a request to do an audit, and that's put on the agenda. And so that letter is always on the agenda, the letter that was written by some member. So you know who wrote the letter or how it was requested, or?
I believe that was a joint request from Senator Hannah Beth Jackson and Assemblywoman Baker, Catherine Baker.
So the judiciary committees were,
Yes.
the judiciary committees of the legislature requested the audit, basically. So Hannah Beth Jackson, Senator, Chair of the Judiciary Committee, Mark Stone, Chair of the Judiciary Committee, Assembly. So they requested. So the Judiciary Committee wanted an audit done on this. So did Judiciary Committee staff communicate with you about the audit request? That's the question.
No.
Okay, so seems like the auditor generally, what happens is once the letter's approved in the JLAC committee, the procedure of the committee is then there's no point that we can modify it because we give the auditor the charge, and then we have a statute of non-interference with a pending audit. You see what I'm saying?
I see.
So we don't get involved. The legislator, because the auditor, we respect the independence of the auditor. And we have a policy of non-interference with the auditor. That's kind of the way our statute is. Okay? We don't go into saying, well, we're going to agree, like, if you wanted to go back and say, well, we don't like you to do this and that and that. We can't interfere. You have to work it out. You have to work it out with the auditor. That's the procedure that the legislature has in the Joint Legislative Audit Committee, because we don't want to get involved in every time there's some kind of dispute to work it out. Now, if the audit is not able to be conducted, the auditor will give us an audit report, and she will say, well, we tried to get the president of the University of California to, as an example, to do this, but we had problems. She'll put that in her report. Mm-hmm. She'll say we can't get the information, and then the committee will say, go ahead, and she'll present it in a report that she writes to us. And then when the report's written, the auditor presents it in public. So in terms of legislative procedure, I think it's very important to respect the process with audits, okay? So that is that you don't interfere with the audit by attempting to go to legislative committees to interject a difference of opinion on an audit during a pending audit, okay?
Right, I understand.
So I'm glad you came here and talked to us about this, but at the same time, we don't interject our opinions while an audit is pending. That's kind of an inviolate rule regarding the auditor. You see what I'm saying? Otherwise, everybody's going to come in, and it's like, okay. And when I was a county supervisor and I worked with you, remember we had audits of the assessor. And the assessor came in and yelled at us because he didn't want to do the audit, and it was a big to-do in the scene. But we don't interfere here. We don't allow that to happen here because we approve. We get a letter. The committee knows exactly what's going to be audited because it's in the letter. We approve that letter, and then the audit is proceeded, and we don't. And once we do that under the rules, we don't interfere with the auditor. It's like we don't call up and say, hey, I wanted you to do something different than what we approved. That is not allowed. That's not allowed. So, and the chair is very careful about that. So I don't know, in terms of anything we can do, it's kind of like, my suggestion is you work with the auditor.
Well,
That's sort of my suggestion.
that makes sense, and then it doesn't politicize the audit process.
We
And
never want to politicize the
Yes.
audit process. We want to keep it an independent process, yeah.
And we have, for only 3 of the issues are there some questions for us. We really don't have any problems with the audit. We are just feeling stuck. And how do we protect people's confidentiality? If we could get a court ruling that said we could turn things over, we will do it. If the court says don't do it, then we'll come back and say, look, the court's saying we have an obligation not to do it. We're feeling very stuck in the middle, but we really don't have problems with those questions, and we've
Right.
got documents ready since September.
Well, and rather than getting into, as my colleague pointed out, we don't really want to get into the substance of what issues might be at question in the audit. From a budgetary point of view, we're in the situation where we fund the state auditor's office, but we also fund the Commission on Judicial Performance. So we're, are we going to have to fund? I guess we're now having to fund the state auditor to defend the lawsuit. So it's not a situation that we like. And why state agencies can't figure out how to do this without going to court. And your baseline adjustment for this coming up fiscal year is already less than what you've spent to date on this court case, which is not yet resolved. So if we look at, the resource of the state going to the purpose for which you all had the intention of the commission, we see instead public monies being diverted to sue a public entity on the question of whether they have the right to audit. So that's the difficulty. And not on any of the substance of it, just.
We're so sorry to be in this position also. We don't want to be, but the legal issues have never been tested before. There's never just been there's no case law on it, and that's why we're
Now, though, I
stuck.
can't believe that there are not situations where the auditor has audited entities that have in statute things that must be confidential. So it's just hard to imagine that there's not provisions for dealing with these confidentiality
And
issues.
we have asked to meet with the auditor's attorney, but I think you'll find with respect to fiscal management, because we have a statement that we provided to your body, that we've been really good fiscal managers. Since 1995, we have given back $5 million to the general fund, because we know that if we don't use all our money, it goes back. And $5 million is a lot of money that we have given back to the general fund. So we don't want to be in this position to use our funds to fight litigation, and we would like to try to resolve this, and we're open to hearing any suggestions.
Madam Chair.
Okay, sorry, Senator Anderson and then Senator Beall, and then we'll move on. Go ahead, Senator Anderson.
I certainly understand the sensitivity. And of course, I don't want you to do the wrong thing, but auditor has audited personnel issues in the past, and clearly they have the same sensitivities, and yet you would think that people would make public records requests for that, and I'm sure that they probably were able to redact the actual names and protect those personnel issues. Madam Chair, I don't know if one of the things that you might want to explore is perhaps a clarifying law. I mean, the beauty is that we could give them in law a path if later down the road, if you want to explore that, I'd be very interested in doing that with you. And then, you know, as I went through this, I certainly understand and appreciate that you're trying to keep the costs down, but at the same time, in your legal defense, you included every argument under the sun, which under normal circumstances, I get that's the normal course, but that's inconsistent with keeping the legal costs down, because you still have to explore arguments that you now say today that are arguments that you think are the most pertinent arguments. So I'm a little, you know, I get it, but on one hand, I don't. And so I appreciate the chair's comments, because I agree with her 100%.
Senator Beall?
Well, just, if it's a legislative issue, that's a separate issue from this committee, but I think the constitutional issues, you might find that the auditor is also in the Constitution, so, you know, just, you know, kind of, there's constitutional provisions for a state auditor, and, you know, statutes related to the procedures and the handling of confidential materials, et cetera. So that's kind of a, I mean, I would say just about every auditor, the audits done has some element of that, you know, personal issues. So they're fairly familiar with, you know, they do have procedures. But I appreciate you being here and explaining this, and I know that you want to have the best quality judiciary in our state, and I appreciate your work on that. I know you work very hard. I know you personally, as you know, being a county supervisor in our county and a judge in our county, and I appreciate the hard work that everybody does on the Judicial Council. So I hope to see the audit come to our committee in the foreseeable future. They will report on the status of audits. They give a report, and I probably would say the process for auditors is that when the audit is approved, that's the time when you can get some of these things worked out. I'll just say that. Okay.
All right, so I'm glad we had the discussion. I didn't in the opening of this, I didn't have a particular resolution, but my interest was mostly budgetary. So perhaps what we could do is, because obviously lawsuits are expensive, and it's ongoing. We can't direct that it stop, but perhaps what we could do is direct our budget staff to work with the LAO and the commission to determine if there's a statutory modification that might assist in addressing these confidentiality issues and that public records portion that is the concern. And that way, perhaps we're able to address statutorily the circumstance so that this can be resolved without necessarily lengthy legal proceeding. Don't know if it'll work or not, but at least we can try.
We're open to looking at anything, and we're so appreciative of your time. Thank you so much.
So is that amenable, that we direct staff to work with LAO and the commission?
And, Madam Chair, I'd also like to thank you all for coming in, and I thank you for your testimony and sharing with us. I didn't want to come off as being curt with you at all. I just know that how efficient this committee runs under Chairman. So, but thank you for coming.
Thank you.
Yes. Yeah, appreciate also, and do recognize there are legitimate confidentiality issues, and if we have to,
I won't.
Go ahead, Senator Beall.
I think it's very important that if you engage on this subject, that we work in the confines of the procedures that are established by the Joint Legislative Audit Committee. So
Yes.
I think you should
Work with
work
JLAC
with our
staff.
JLAC and the auditor on this
Okay.
issue if you want to pursue this.
Okay, I
So I
understand.
think we have to maintain
Right.
a distance, if you want to say, in terms of dealing with the audit itself versus some other.
Yeah, no, I appreciate that
know,
because it may be,
it
and
would
again,
look- it would
we,
look- we want to avoid the
correct,
perception
that
of
we are.
interference with the
Correct,
audit.
correct. And there also, it is possible that if staff in interacting with the JLAC and the JLAC staff and auditor, that there may be provisions that address the confidentiality, that, in other words, no additional action is needed. So I appreciate that addition, Senator Beall, and thank you for bringing it up, so.
It's a hard job.
Okay.
auditing.
All right, so then we're basically going to leave this to asking LAO and JLAC and the auditor staff and the commission to identify whether there's any thing that needs to be resolved on the confidentiality area. And if it's already adequately resolved, then there will be no action by us. All right. Okay. So much. Thank you.